few minutes early.
I thought we were pretty close, according to your computer. So everybody who's seated is our regular members. Need a motion on the minutes.
Second.
Motion by Schmidt, second by Lang. Any additions, deletions, corrections to the minutes? Seeing none, all those in favor?
Aye.
Any objections? Okay, a motion on the consent agenda. Motion by Schmidt, second by McGuire. Are there any changes? All those in favor?
Aye.
Any opposed? And a motion on the postponement list, which is quite extensive.
I move to postpone the items on the postponement list, including requesting the waivers necessary. Second.
Motion by McGuire, second by Lang.
Mr. Chairman, there are 2 or 3 items that are specifically, it says postponed to October 20th. All the rest would be postponed to October 6th.
Yeah.
Correct.
Yeah. Okay, the regular agenda. OPLC.
Okay, sir, this is, as you said, an OPLC rule that regulates electrologists. Previously, administration of these providers was under the Department of Health and Human Services, but that administration was transferred to the OPLC in 2015. The rules that the Department of Health and Human Services had in HEP 1300 expired on December 11th, 2017. So the committee may have some questions about that. There are a few other issues to go through. If you want, I can go ahead and start going through those, and then we can circle back to the agency, or if you want to talk to the agency now about the expired rules, however you want to do it, sir.
Just go ahead.
You got it. Okay, so besides that issue, if you look on page 9 of the PDF, there's just a note there around the committee's continued support of the executive director and having fee authority. There's also a note on page 12 that can be disregarded regarding the need for legislation, as there was a House Bill 1062 from last session that removed the authority or the requirement of this committee to conduct the licensee examinations that can now be done by a third-party vendor. Finally, there's a comment on page 14, because the rule appears to allow applicants, and this is on a couple of places in the rule, to choose what fee they want to pay. So the rule says the fee is $155 or whatever's in PLC 1002. And what's noteworthy is that the form says the fee is $110. So it's not clear what the applicant is supposed to pay, and it's not clear if the intent is just to allow the applicant to choose whatever they want to pay. So that issue also appears on another page as well, and that's in regard to the owners of of these schools to submit a fee and to submit information. That's on pages 27 and 28, and then 29 through 30. So there, the owners can just submit information in order to get that permission, that license to open their school. OPLC says there's no form for that, but it does require that the applicant certify and attest. So it's not clear how they're supposed to do that. The rule also doesn't specify where this information is sent, whether that's email or to OPLC or et cetera. So, and again, it also says that the applicant can choose what to pay, and there's no explanation as to what happens if the fees are different, either in this rule or over in the other 1002 rule. So that's at a high level the issues with this proposal, sir.
Good morning. My name is Douglas Osterhout. I'm General Counsel for the Office of Professional Licensure and Certification. As far as the fees go, the lower amount would be paid. The IP for this started in rulemaking prior to the PLC 1002s being in rulemaking, so the specific fee was included here. We could revise the language to read the renewal application processing fee specified in PLC 1002 if that would clear things up.
I think that would. I think we need to make sure that what's on the form is the same as what's in the 1002 rule. As I said, the form indicates that, and this is on page 10 or 14 of the PDF, if you're looking at that, 10 of the rule proposal, it says the form indicates the fee's 110, but then the rule text says 115 or 155, but then it says or the amount required by PLC 1002. So I think removing the application fee here is fine, but then we still need to make sure is it the same as what's, on the form.
We'll make sure the form matches. I'll work with Gretchen to make sure that happens.
And then I think you were going to probably hit down to the other issue with the owners and the licensing, where to submit the information. I think that all starts around page 27. So if you look at the page 28 of the link to documents, page 24 of the fixed text document, it says the owner shall submit the request with a processing fee of $375 or the amount established in 1002 if different. So again, I guess maybe.
I think it's the same solution. We can change the language. We can revise that to the owner shall submit the request with the processing fee established in PLC 1002. And
Yeah.
I think the same solution would fix both issues.
I think that would do it. And I think we probably need another paragraph in this section. And this is 708.03. We need another paragraph in there that tells the applicants where to submit this information.
I'll work with Gretchen on that.
And then we need to know too how the applicant can submit a certification statement. So I guess maybe just needs to spell that out a little bit more clearly in the rule.
So we're just looking for clarifying language. Okay.
Good. Go ahead.
About the fact that the rule's been expired for 5 years.
Unfortunately, I don't have a lot of history on that. I only started in January, and as soon as the rules came over to OPLC and they became an advisory board, we started drafting rules to get them in place right away.
Can I ask what you've been doing in over the last 5 years regarding, fees and applications and licenses and such like?
Have any history on it?
Unfortunately, yeah, I wasn't expecting that question. I can do some research and I can get you an answer, but I don't have an answer for you today. Now, I do know Executive Director Courtney makes it a point not to collect fees, that she doesn't have the authority to do so. So that would fall in line with her way of doing business.
Mr. Chair, I move we object to the rule on the grounds of staff comments and invite you to submit a corrective proposal and also provide a report on the activities since the previous rules expired.
Thank you, Mr. Chair. I also have another request with that. Fees support activity, and they're directed to that activity.
Yes,
And
sir.
there's parameters that they have to stay within, and that's why those fees exist. You need authorization to charge the fees. So here's my question. I need to know the mechanisms that were utilized to fund this activity, this is important and it has to be very clear and explicit. And if the fees were not collected, what monies were utilized to support this activity? Because again, the department had zero authority to assess fees. They had zero authority to actually do anything around the realms of this activity. And that's the seriousness that this has to be held. So am I clear in what I would be expecting?
Yes, sir. So I want to repeat it back to you to make sure.
Thank you.
Mechanisms that are utilized to fund activities, and if fees were not collected, what fees were utilized? Second,
If in fact the fees were not collected.
if they
I-
were correct.
And if they were collected, I need to know an accounting of that. If that's okay, Mr. Chair.
I will gladly accept that amendment to my motion.
Thank you, and thank you, sir.
I'll second the motion.
Thank you. Motion by McGuire, amendment by Hatch, second by Burstein. And let's finish this. Any other discussion or questions from the committee? Seeing none, all those in favor? Any no? And we'll seat Representative Schuett for Senator Whitley.
Mr. Chairman,
Yes.
I've been informed that there was no vote on the postponement issue.
Okay, we had a motion and a second on postponements. All those in favor?
Aye.
Thank you.
No, I didn't hear it. Everybody voted. Okay, LADAC Board.
Okay, this proposal makes changes to the alcohol and other drug use professional rules. The agency has filed a conditional approval request, which has resolved all the issues. There is just one issue, and that is related to the fact that the rules have been expired since 2017.
Representative McGuire.
Yes, please explain.
Yes, so even though these rules were expired, we relied on the Department of Justice rules. Is that what it was? For LADAC, yes.
So there's rules JUS 800s, which allow us to hold. There's sort of gap filler catch-all for adjudicative hearings under administrative boards. Oh, sure. I was saying the Justice 800s can be used as sort of gap filler for administrative hearings in the event that something like LADAC's rules would lapse. Now, currently, there's also the PLC 200s, which went into effect early August 4th or August 8th. I'm not sure.
If you have two sets of rules governing this, why are you putting up a third set?
The rules for OPLC are intended to cover the couple of reasons. Are meant to cover the advisory boards who wouldn't have rules. We're hoping in an effort to streamline the system to eventually get a lot of the boards to adapt the 200s. Some of those committees have already done that. I believe acupuncture has made a motion to do that. Midwifery has decided to go in that direction. And they're also there's language in there that they're meant to supplement rules and not circumvent or oversee. So if there are rules in the individual committees, they can also be used. Would it help if I provided an example of this sort of thing? Okay, so there's in a lot of the statutes, there'll be reference to, say, an emergency suspension where a board can take action against a licensee, but they have to have a hearing within 10 days. And those are in emergency situations. What we were finding was a lot of the rule sets, while they may have it in statute, didn't have specific rules to address how an emergency hearing, the timing, those types of things would occur. So the PLC 200s can be used in those sort of instances. And that's based on the PLC, or no, RSA 310 A1D, Roman numeral 2 H2, which gives us the authority to promulgate rules for those types of processes.
Okay.
So what is the difference between these rules and the OPLC rules? Are these more detailed? Are they more focused on issues with latex or what?
These sections across all of the
Identify
board.
yourself.
Tina Kelly, Program Specialist with the Office of Professional Licensure and Certification. These rules are pretty much the same across the various boards, and so they're pretty standard rules that are used. And I'm guessing that OPLC has the same standard of rules. They might be worded a little bit different, but they do the same thing.
If they do the same thing, why duplicate? Why bother? Why put us all through this?
Go ahead, Mo.
So maybe it'd be beneficial just to speak briefly, very briefly, because this is an ongoing issue and it needs to be rectified. I haven't heard the causation for the lack of the rules being submitted in a timely manner. So is that a process problem, or what is the problem to that? Personnel problem? And maybe if you could, I'm sorry to go on, but explain the process. Now, does these rules go to like the Governor's Council of Alcohol and Drugs first, and they have to go through and agree on said set of rules, or what is the process for that, and where are we getting tripped up? And if it could be done in a very short period of time, and with the chair's indulgent, could we do that? And that might help us.
Yep. So what has happened is we went back and we identified through all the boards which rules were expiring, which rules are going to expire. That process has been now put into place. What we're doing right now is trying to get everything caught up. So as soon as all these expired rules are caught up and we have them adopted, there's a system now in place so that this will not happen down the road.
Thank you. That's what I was looking for, and thank you for that.
Yes, that, I still have the question of, even if the specific alcohol procedural rules were expired, the fact that you've got Department of Justice rules and OPLC rules that cover the activities, why are you bothering to put these through instead of just referencing the OPLC rules?
So it's my understanding that all the boards have had these in place, and the boards are the ones determining legal issues within their specific boards. And that what OPLC is trying to do is to work with the boards individually to have them, if they choose, move over to OPLCs, then these would be revised to just refer to OPLC's rules. They're trying to work collaboratively with the boards so there's buy-in.
Could I,
So, I mean, just for clarity, why there is an additional set of rules, the ones that are out of the OPLC or the different boards, such as the alcohol board, are more explicit, but you're using the 200 authority to adjudicate things under those more explicit rules provided by the boards. Is that not correct? So there isn't a duplication of verbiage. The rules are defined a little differently within, or more explicitly within the different boards than the 200 rules. Is that not correct? It's not a duplication per se. And they're using the 200 rules to authorize them to adjudicate under the explicit verbiage from the different boards. Is that a correct scenario? Is that what we're looking for?
So I think, yes, I think so. I think so. And there's a question of ease for the user too on the end. So they can go right to their rules, they can look at those statutes. And then if there was something that wasn't addressed in their rules, that's where they might turn to the Justice 800s in the past. Now they might turn to the PLC 200s to sort of supplement the thing they know, the thing they're comfortable with. And as Tina pointed out, we are working with the boards to try and get everyone to adopt eventually. That's a long-term goal. We'll see how it goes.
Mr. Chairman? Mr. Chairman?
Yes.
I think Kim can clarify this for the committee.
Just going to point out the statute that OPLC is referring to is 310A1-D. So that is titled Administration of the Office of Professional Licensure and Certification. Specifically, H2 talks about what grants them authority. It says such organization and procedural rules necessary to administer the boards, commissions, councils, and programs in the office, including rules governing the administration of complaints and investigations, hearings, disciplinary proceedings, payment processing procedures, and application procedures. The boards shall retain the authority to determine the criteria necessary for licensing applications. So that seems to be how that is partitioned out.
Diane?
Oh, I tend to agree with Representative McGuire. I'm not sure I see the need for two sets. But
So we still need a motion to approve the rule.
So move.
Motion by Hatch, second by Schmidt. Second by Schmidt. Any further discussion? Seeing none, all those in favor? Any opposed? Okay. We have 3 opposed. The motion carries. Board of Veterinary Medicine.
Yes, sir. This proposal also makes changes to the rules on the practice of veterinary medicine. I don't have any substantive comments, just as the rule set that we heard before. These rules have been expired since 2020, so the committee may want to ask some questions about enforcement of this rule.
So I know for this one, there was a mistake. OPLC received fees for renewals last year, but we are in the process of refunding those rules. We have not been collecting fees for initial licensure since then. Renewals happen every December, so the renewal piece hasn't been an issue since last year. I found out about this January, February after I started. We made it a priority to get all the vet board rules moving forward. As far as discipline goes, there was only one disciplinary action. Again, we could rely on the Justice 800 rules, and that was a violation of statute. We were still able to issue licenses, renewals, and initial licenses because there's statutory authority that allows the OPLC to do that. That would be 332B9.
Mr. Chairman, so the committee is aware, until recently, the veterinary rules were under the Department of Agriculture, and they have now moved over to OPLC.
Okay. Questions from the committee? Seeing none. Looking for a motion. Motion by McGuire, second by Hatch.
That's for all 3 of them, unless there's any. I'm sorry. Uh, Unless the staff objects, that would be for all 3 sets of rules.
So to clarify, that would be for, well, yes, it would be for 89, 90, and 102.
Correct.
Yes, ma'am.
Okay, any further questions or discussion from the committee? This is to approve C, D, and E, all 3 rules. All those in favor?
Perhaps we could just have something from the Agriculture Department to provide the links. I understand the carry forward from the Agriculture Department and so forth to OPLC, but I think we have to have something, in writing that reads to that effect. Thank you.
If I could, please, the motion for 90 should be conditionally approved. There was a conditional approval request for that proposal.
Okay, we'll accept that. Any further discussion from the committee? Real Estate Commission.
Okay, this proposal was conditionally approved by the committee in July, and it was based on the agency's conditional approval request. But the response made a number of amendments which were not part of the conditional approval request. Many of the amendments are editorial. Some of them are not annotated. There are a couple of substantive changes that could be argued either as substantive or editorial. If you look on page 6, there is the deletion of a fee, but a couple of subparagraphs before it is a citation to that same fee, so that's why that has been deleted. And then there's an insertion of the word broker in quite a few places. It sounds like this was part of cleanup by the board after the fact. And then there's a new requirement granting permission that if a person grants permission, that a personal email address can be used, and that's on page 7. So again, I have no other comments other than just to give you a high-level summary of the changes that were made that were not included in the conditional approval request.
Questions from the committee? Looking for, Carol.
Yes, thank you. Do I understand you correctly that the objection response would generate no objections?
Yes, ma'am. I think it could be argued, as I said, one way or the other, that these changes on page 7 of the PDF, I believe that sentence was actually in the rule further up the road, if you will, I think in the final proposal, but it gotten moved out. So it's in here now. Some of the other changes appear to be cleanup. I think Tina can speak to why the board chose this moment to make these changes instead of having them in the conditional approval request at the outset.
Go ahead.
Hi, Tina Kelly, Program Specialist, OPLC. I brought it to the board. I explained to them what would happen if they made these changes and that and to only do it if it was imperative. They felt that it was imperative. They knew that it would result in a preliminary objection response, and they were adamant that these be changed for clarity's sake and the correctness of the rules. They've been working on them. They've made more changes over time. Why they waited to this moment to make these few changes, I can't answer to that. They just noticed them is my best answer.
Sir, if I could too, it has just come to my attention that the committee didn't vote on the 3 vet rules. I think the motions were made, but no voting actually took place. Is that correct?
Yeah, we voted.
Oh, we got, did we?
Yeah.
Okay. 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 Sorry, Mike was thinking that we hadn't voted. I wasn't sure.
I move to approve these rules with the,
Second.
Motion by McGuire, second by Lang. Discussion. Seeing none, all those in favor? Any opposed? Department of Revenue Administration.
So, Mr. Chair, there were a number of comments on this particular rule, the 2022-114. However, just so the committee is aware, the agency did reach out with a conditional approval request past the deadline. And so I did initial review of that, as it does need a waiver, so I couldn't submit it as an actual conditional approval. And if the agency would like to request a waiver at this time, then perhaps we could discuss that first, as it does take care of a number of the comments.
Okay, so need a motion for the waiver.
So moved.
Rules.
Second.
Motion by Lang, second by Schmidt. All those in favor?
Aye.
Thank you, Mr. Chair. So the remaining comments that are on this particular rule, the first is on page 1. It's just a note to the committee that this particular agency does have an exemption from RSA 541A for its forms. They do not have to be incorporated by reference, do not need addition dates, and may be changed outside of the RSA 541A process. However, there were still a couple comments with regard to the forms outside of these parameters. The first is that a number of the forms asked that they be signed under the penalties of perjury, specifically Form CD 57P, which is on first referenced on page 2, CD 57S, also on page 2, CD 57 HCP, also on page 2, CD 57 HCS, also on page 2 of the rule, DP 151, which appears on pages 5 and 16 of the rule, CD 92, which appear on page 7 and 15 of the rule, AU 202, page 10 of the rule, AU 201, page 13 of the rule, and DP 8, which appears on page 18 of the rule. The agency has provided the explanation that RSA 21J 39(2)D provides them with broad authority to use penalties of perjury on their form. However, staff disagrees with this analysis of the statute. The statutory language specifically is, with respect to any tax administered by the department, no person shall willfully make and subscribe any return, report, statement, or other document that contains or is verified by a written declaration that is made under the penalties of perjury, and that he does not believe to be true and correct as to every material matter. The staff would argue that this language is stating that no person shall provide misleading or incorrect information on a form that already contains the declaration. It does not give permission for the declaration to be included on all forms. And this is further supported by the fact that a number of the other forms included with this rule have statutes that specifically allow them to be signed under the pains and penalties of perjury. Specifically, the forms that relate to the tobacco tax. RSA 7842 specifically says the commissioner shall adopt rules pursuant to RSA 541A relative to the form of such return and the data which it must contain for the correct computation of tobacco tax attributable to the state. The consumer shall sign the return subject to the pains and penalties of perjury. This is also found in RSA 8210 1A, which is under the taxation of railroads, and similarly under RSA 83F5, which also has the statement that the commissioner shall require and shall be signed by an authorized representative subject to the pains and penalties of perjury. The additional comments that I have for this particular rule is on page 2 of the rule, page 8 of the packet under revenue 809.05. Those forms that are listed in that particular rule are forms that are the declaration of consideration, and the statute regarding the declaration of consideration forms, RSA 78B101A, does have specific statutory language it requires on the form, and the forms seem to admit part of that statutory language, specifically the agree and affirm that the full price or consideration for the real estate transferred is X amount of dollars. Instead, the forms state, I declare that I have examined this return to the best of my belief. It is true, correct, and complete. Staff would argue that these are two very different requirements, and therefore the agree and affirm should be added to that particular form. The next comment is on page 4 of the rule, page 10 of the packet under revenue 1002.01E. The agency uses the word sufficient to describe the number of stamps purchased. And though this is the same language that is used in the statute, under RSA 541A1 15, the rules are meant to interpret or make clearer the statute. So the word sufficient is a bit vague and should be clarified further so that the wholesaler knows exactly how many stamps they need to keep on hand in order not to be penalized by the agency. The next comment, I apologize, the rest of the comments are addressed on the agency's conditional approval request for changes. So that's all the comments staff have at this time.
So what do we recommend to do about this?
I would recommend, Mr. Chair, that the committee conditionally approve this rule with an amendment to the already submitted conditional approval that the forms that require under pains of under the penalties of perjury language be changed, as they don't have the statutory authority to include that on their forms. That the form that requires the statutory language be also amended to include the affirm language in the statute, and that the agency changed the word sufficient to be clearer and more defined on what number of stamps the wholesaler needs to include under the rules.
So we don't see a need for a statutory change.
I do not, Mr. Chair.
Mike?
Regarding the perjury issue, RSA 641, 1 through 3, sets penalties for making false statements. 641.1 is perjury, which is a criminal penalty. 641.2 and 3 are lesser penalties, they're violations. It's been the long-standing position of staff and the committee itself that you cannot use a rule to impose a criminal penalty unless you have specific statutory authority.
So I guess if I may, Mr. Chair, before I make a motion though, could the department respond to what they need to do to address this and the severity of it, I guess? Thank you.
Good morning, Keen Ming Wong of the Department of Revenue. So we did look into this, and we did consider the issues that was pointed out by OLS staff, and we do find that we are operating within the confines of the statutory language. Specifically, these are on the forms, and the forms are exempt from 541-A requirements. This is stated in the RSA 541-A21-5, Roman 5, and in our DRA statute as well, RSA 21J13-A. And just to give some background on what I found on the history, legislative history of these statutes. So the exemption of DRA forms from the 541A requirement started in 1996. So that statute enacted in 1996 exempts the business profits tax forms, BET forms, and IND forms specifically from the 541A requirement. And then 14 years later, in 2010, statutory legislation expanded that exemption to all DRA forms. And with that, we feel that we are still acting within the authority of the statute. And also, just to add to that, DRA's functions, and so DRA is charged under 21J1(2) to oversee the collections of state taxes, as well as to provide information collected through tax administration to governor and general counsel for public policy decisions. And it's really imperative that we are able to really rely on the information that we receive from filers, that it's accurate, and that we can be able to provide this service to the governor and general counsel. And it's also imperative that for us to be able to rely on that. So on the flip side, that the people who are filing this information should be accountable for that information as well. In terms of the statutory, legislative statutory authority as well, is that as mentioned by OLS staff, there's a RSA 21J39(2)(d). The way we read it is that it allows us to have that level of attestation on all the forms, on all our DRA forms. And also, the legislature has also recognized that it's important for us that the level of information that we provide is accurate. So it also provides the commissioner with authority to summon the production of papers and documents relating to any tax matters, which the commissioner has authority to investigate, and that's in 21J3, Roman 9. And also we also make reference to the New Hampshire Criminal Code, as mentioned by OLS staff as well. In regards to why some of the statutes, some of the operating statutes, has specific language for the pains of penalties of perjury, while some statutes do not. I can only submit that it is likely that that legislature probably saw that the inconsistencies in those different statutes, and might resolve it through the requirement to say, okay, yes, allowing the forms to be governed under the more overarching umbrella of the 21J statute, and therefore imposing a more standardized treatment to all the forms.
Mike?
When a court is looking at legislative intent, statutory construction, if they see in some places where statutes under a specific chapter authorize perjury, and in other places it does not, the court is going to assume that it was legislative intent where it did not impose perjury, that was what the legislature intended.
I think I rely on staff's comments, and I'm not at all qualified to arbitrate this debate in any ways. I do recall why this authority to change forms was given. I was here, and it was for expedience purposes. IRS changes rules and would mandate a change in your forms, and the JALCAR process did not afford the DRA to be timely enough in changing the forms to comply with. The chair probably remembers this, but anyways, I think, well, I'm not sure what we need. I would propose a conditional approval based on staff comments, or maybe an objection. I'm not sure what would resolve this, but it does need to be resolved. And I would suggest that the agency submit for statutory corrections to address this issue. And I wouldn't see that there would be a lot of problem in obtaining that, just not very timely. So I'm not sure what would work best, and I would just need some advice on that from maybe staff, or where we are in the time factor for this rule, if there is time allowed to do that. Am I clear enough, Mr. Chair?
Yeah, I concur, Bill.
If I may, Mr. Chair, what the committee could potentially do is a conditional approval with the recommendation that the agency pursue legislative change.
Okay, so you agree with, you need a legislative,
No, I think we are able to submit a legislative proposal to if that's needed. Yeah. I think
okay,
we're still
so
within the.
let's revisit this at the continued meeting for approval. So we make sure that,
Mr. Chair, the two proposals that were pushed to the October 20th meeting are actually the Department of Revenues, because they are unavailable to be at the continued meeting on October 6th.
okay. So we'll do that. Do we need to waive anything to do that? Okay. We'll see you again.
Right. Just to clarify, is there any action on our part between now and the 20th?
I think you should be prepared at that meeting to say, we need to change this statute to include the penalty of perjury, for
Okay.
example. And what was the other? I remember that if you need specific authority for perjury, then you need to have it every place that it's applicable. What was the other statutory change?
On one of the forms, there's statutory language that's required in the form to affirm, and so that language needs to be changed.
Yes, either the form or the statute needs to be changed.
Yeah, that second item mentioned is much easier. Yes, definitely. Yep.
Okay, and Representative Hatch has agreed to be the prime sponsor if there are legislative changes needed to be sponsored.
Thank you.
If I may, Mr. Chair, to effect that, you would need to contact me. I'm always available. I will not follow up with you until you come to me with what you need. Just
sure.
so that's clear. Thank you.
Yes, thank you. Shall we also address the issue with the sufficiency language?
Do you have a response to that?
Yes. Hang on. The issue with the sufficiency terminology that's used, that's in the tobacco tax rule, also in the tobacco tax RSA. And that specifically relates to the sufficiency of stamps, tax stamps that's required by the wholesalers. So wholesalers, they keep tobacco products, cigarettes and little cigars in various locations in New Hampshire. And it is the requirement by statute that the wholesalers would need to maintain a sufficient amount of stamps to be attached to all the tobacco products. So that is that terminology of sufficiency. So from the DRA standpoint, we do not know how many products that the wholesaler would have maintained in each of these locations, and therefore reading the language in the rule as well as the statute, they're both consistent. in that requiring that, okay, it is the wholesalers who know what is their, we're not requiring them to keep additional stamps. We just require them to keep the amount of stamps that is required to be attached to all the products that's available on location. That's the use of the word sufficient.
And if I may, this particular language is already in the existing rule. It was brought up as a staff comment the last time these rules went through the process, and the rule was still adopted with that language in place. However, for consistency, staff felt it should be brought up again for this committee.
Okay. Well, go ahead.
I'm sorry to belabor this, but to that end, could you just say why that word sufficient? We don't like relative terms, and that's a relative term. But I have some understanding of the process for tax stamps. So your wholesaler has an enormous inventory of tobacco products. And would it be that it would be impractical to require them to have sufficient stamps available on site for all inventory in place? Or what is the reason that the insistence of sufficient is used as opposed to explicit, say, as enough stamps to cover current inventory or something such as that? I mean, I understand the process, and maybe that won't be a workable thing for wholesalers, but could you just speak to that briefly, if that would be okay, Mr. Chair?
Sure.
I think that's to your point, Representative. I think that's achieves the same results. So I guess changing the language to say what you propose, I think that should work for us.
Okay, but just my concern is that practical? That's
Oh,
I would like to understand that, knowing somewhat about the process, that how it works.
I would, my apologies, I wouldn't know whether how practical it is from the wholesaler's position, whether they would know how much products they have in the warehouse and how much they're planning to have in the warehouse or wherever location that they have, and they should, according to the statute, they should bake into their process of ordering the products into the state or into the location the same time of obtaining the stamps required to attach to all the products.
Okay. Okay.
Well,
we'll
we
see you-
shouldn't try to fix this on the fly. So they're going to, did I hear you say, Mr. Chairman, that we're going to have a continued meeting
No, they'll be at the next regular.
at the next regular meeting? Okay. So we just need to work this all out. So we're not doing it on the fly right now. We have to
Right.
have it
We're not
specific so
doing it
that
now.
it's workable
Okay.
for the,
Thank you.
I'm sorry, Mr. Chair, if I may, just, so to that point, when you come back, maybe if, and I'm not anyway suggesting to tell you what to do or not to do, but I think I would be a little bit comforted if you did have a dialogue with the wholesalers to get feedback as to what might be required and is that practical or not. I would hate to mandate that if it was totally impractical, and I'm not sure it is or isn't, Mr. Chair. I'm sorry.
They'll be in touch with you about this.
Thank you.
But Representative, it is a requirement in the statute, so it's not an additional requirement imposed on the rule. It's not a.
Okay.
Okay,
Thank you.
thank you.
Insurance Department. No, it's just going to deal with it at a future date. Proceed.
Thank you, Mr. Chair. So this particular rule The first comment is on page 2. It's a note to jail car in that insurance 350201A1B2 has some included language, the language being or any other valuation mortality table adopted by the National Association of Insurance Commissioner after the 2022 effective date of this rule and promulgated by the rule of the commissioner for this purpose is not consistent with the rule that is cited in that particular section. This comment also continues on to a couple other sections on that page, as well as on page 3, where that language appears in this rule but does not appear in the rule that is cited. Therefore, the rules are inconsistent, and if these rules were to be adopted, the other rules would have to go through the rulemaking process to be changed to be consistent.
Go ahead.
Thank you, Mr. Chair. That language is totally unacceptable, because if you're going to have to adopt it by rule, you can change this rule. We can't just give them the authority to adopt an update without any kind of approval. It's unconstitutional, and it's a concern. If they're going to have to adopt it by rule, they can change the language to say use this one. We have to be specific in the rules as to what tables or data we're picking up from somebody else. And so I would like to make that point very strongly.
Tell us who you are.
I'm Heather Silverstein. I'm General Counsel with the Insurance Department, and I'm very eager to address this comment. This was not in our initial proposal. This was suggested by the committee's attorneys to put this in, and so we'd just be as happy. It's not in the model rule, as you may remember. We follow the National Association of Insurance Commissioners, the model language. That paraphrase is not in the model. It was suggested to put it in. And so we did that, and then after we put it in, we were told, well, now you got to change all your other rules. So I would we would just as happy to take that out. It's not in the model, it's not needed. And then the other issue is we don't want to amend our other related rules before the NEIC does. Because the NEIC, it's a nationwide process. You get input from industry and consumer groups and whatnot. And so the idea of trying to jam through and updating all these other rules before the NEIC does, we are not interested in that. We just want to deal with this specific rule, and this rule does expire in October, and so it is a rule that we need for accreditation, which is very important to us. So we'd be happy just to keep it the way the model is, which does not contain that.
Yes.
So the reason that language was suggested by staff is because the other sections in insurance 3507.05A, some of them referred to the 2022 new table, while these other ones did not. So that was brought up to the agency as a question and a concern that some of them were using the updated table and the other ones were not. And that's when that proposed language was included, just to give that history to the committee.
Conditionally approve this.
So that, if I understand you correctly, you would be perfectly happy to put a period after the 2001 CSO mortality table.
Yes, that's correct.
Yeah, thank you.
Okay.
The other comments that were on this particular rule have to do with the waivers section. There was a comment above that with regard to the citing of a date of January yeah, I apologize. Page 3 of the rule, page 6 of the packet, there was a date cited to the rule, in the rule, January 1st, 2005. So there was an initial comment put on there with regard to when that date was actually included in the rules. If it had been after that date, it would have been an authority comment, but after speaking with the agency, we are withdrawing that comment as that date had been in the rules since 2004. So the remainder of the comments are on page 3 with regard to the waiver section. The first comment is an unclear comment, as the waiver section does not include how how the agency is going to determine how long a waiver will last. RSA 541A 22(4) states that waivers can only be put into applied if they are specifically put into rules, and additionally, they have to be clear about whether or not a waiver is going to be temporary, if temporary waivers will be granted. There's no language here providing how long a waiver would last, and therefore if temporary waivers will actually be allowed in this rule. The other comments with regard to the section is another unclear comment, as the rule insurance 3507.07A1 specifically states applying the rule provision would cause confusion or would be misleading to consumers. Staff had an unclear comment on that, as if a rule is unclear or confusing to consumers, then the rule itself is unclear and therefore should be addressed by the committee. And the final comment is another unclear comment in insurance 3507.07C, where the agency's rule requests a written waiver needs to be made, but it does not state to whom that waiver needs to be made to.
And my comments as to the waiver provisions, this waiver provision we started putting in our rules, in all of our rules, back around 2016. I remember because I was the attorney that started doing that, getting the rules up to speed. Part of that process, we engaged jail court attorneys at that time. When we were developing the language, we also looked to other agencies that had similar language. Like I know Public Utilities Commission has very same language, actually. So we were trying to be consistent with what other agencies were doing. So that's how we developed the language. It's in about 30% of our rules now. And it's so we don't want a situation to happen where we have to waive a rule. We couldn't waive a rule. You don't want the situation to happen where something can't be done and you're stuck because you don't have a waiver in your rule, which is exactly why we did it. For history, we've had about 10 requests for waivers since 2018. We've granted 7 and 3 of them were withdrawn. If the waiver is not looking great, like if we don't think we're going to grant the waiver, we usually tell the licensee it's not looking really good, and then they'll withdraw the waiver. So we publish all of our waivers so everybody knows if we grant a waiver for a rule. The reason we've been resistant in the past, because we've had this objection before, as to setting a very specific time limit on a waiver, is because the circumstances change all the time. And we could have a rule that, in fact, that's what happened with the very first waiver that we granted. We could have a rule that is updated and replaces the need for a waiver. So then you wouldn't obviously want the waiver to be in place, because the rule is going to take over and be in effect to handle that very situation. And that was for a new product, because we have new insurance products all the time, and sometimes our rules are not caught up to the industry. And so that's like a common reason. Honestly, for this particular rule, I highly suspect we would not use a waiver. This is a rule where we need it for accreditation. It's setting liquid reserves for life insurance policies. So I don't think that we would use a waiver in this particular rule. However, for consistency and because we never know what's going to happen, we have added it to this particular rule.
Recommendation from the staff?
At this time, there was no conditional approval request submitted by the agency. So the committee could either approve this rule as written. However, it sounds as though a conditional approval may be more appropriate to take out that additional language that was added in with regard to insurance 3507.05 and or preliminary objection for the agency to respond with a objection response to correct that.
I'd like to ask if you would be willing to insert in the waiver language that the request in writing goes to whomever gets them, the commissioner or whomever. That doesn't seem like it would cause any confusion. And the other part is that I like the idea of saying the waiver will be granted for the duration requested, or if they're all permanent, whatever the case is. But I think it's important to indicate that, you know, if you ask for a waiver, sometimes it's forever and sometimes it's not.
So just to be clear, we would put that in the conditional approval, get rid of, there's 3 comments to get rid of that paraphrase, 3 comments to get rid of the paraphrase so that the period goes after CSO mortality table, in writing to the commissioner, and then add the language for the duration requested under the waiver. And the department would be agreeable to that.
Then I move that we request
Okay.
is that a preliminary objection so that they can prepare the correction?
Okay.
I move a preliminary objection for that purpose.
Second that motion.
So my only comment is that this expires October 1st, so I want to make sure that we are able to get in what we need to before October 1st. However we do the process.
Isn't it extended by virtue of your being in rulemaking?
That is correct. Because you've started the rulemaking process, the expiration of those rules will not occur until the new rules are adopted.
Okay, I just want to clarify.
I appreciate your checking on that.
Okay, motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed?
Thank you.
Thank you. Charitable trusts.
Thank you, Mr. Chair. So the first comment with regard to these rules is on page 1. It's actually a note to jail car. The Department of Justice has had the rulemaking authority regarding charitable trusts since 1987. That's an RSA 722. This proposal appears to be the first time that the agency has done rules for charitable trusts. So the committee may have questions on how the department has been enforcing its current practices without rules. The next comments, a number of these comments have been addressed in the conditional approval request that was submitted by the department, specifically with regard to the forms. There were a number of forms submitted with this particular rule, but pretty much all of them were addressed in the conditional approval request. The only ones that are remaining are the ones specifically like the rule we just discussed. The waiver section of the rules had pretty much the same comments that we just discussed for insurance. There was a provision that a waiver may be given to a rule if it is essentially unclear. And there was also the requirement that a waiver be submitted in writing, however, it does not say to whom. And finally, there is no length of duration for the waiver in the rules as well.
Tell us who you are and
Good morning, Mr. Chair. My name is Diane Quinlan. I'm the Director of Charitable Trust at the Attorney General's Office. I'd like to begin by respectfully requesting 2 amendments to our request for conditional approval. I have written proposals here this morning, and I apologize for the late notice. I can distribute them now or describe them first.
we're not going to take written comments now.
All right, thank you, Mr. Chair. The first amendment would be to eliminate a couple of rules that I don't think are necessary. And the other is to address the concern about the waiver. We've added language, we propose language that says any person or entity seeking a waiver shall submit to the director a written request specifying the nature and duration of the waiver sought. And so we hope that that will address the concerns of the staff.
That does address our concern.
Okay.
Mr. Chair?
Yeah.
Is there a deadline on this, or we were to continue this until the next meeting to have staff have a chance to review the written changes so we could address it at the next meeting? Would that be
What's the
appropriate?
staff's?
So this language was actually provided to our office yesterday. And so I did have an opportunity to
Okay.
briefly review, and the changes do address the remaining staff comments.
Okay.
The only issue was that a waiver was needed. So the agency had to make an oral request for a waiver. And then additionally, with the deletion of the language, that was something that was new that I wasn't sure if the committee would have additional questions on, of why that language was being deleted from the proposal. So if the committee would like to address this at the next meeting, then the agency could submit its proposed changes as an amended conditional approval, and we could address it again at the next meeting. Or if the
Where are you with this?
I am, as the amended conditional approval does address all my comments, so the language proposed satisfies
Mr.
staff
Chair?
comments.
Yeah, let's not push anything else off to an
But-
already.
So I was gonna
large
make a
agenda.
motion to accept the waiver and have the amended comments added.
Motion, second. Second by Hatch. Any further discussion? Seeing none, all those in favor?
Aye.
Any opposed? Motion carries.
Mr. Chair, I move approval of the amended approval, the amended request. No, we voted to waive. We
Yeah.
voted to waive to allow them to put the amendment in. If I'm not mistaken, then now we're
Okay,
voting to
just in
actually accept
case.
the amendment.
Any discussion? You've heard the motion and the second. All those in favor?
Aye.
Any opposed?
Who seconded that motion, sir?
Great.
Mr. Chair, may I ask a question?
No. Address the staff at your convenience.
Okay.
Public Utilities Commission.
Okay, this proposal makes changes to the municipal and county aggregation rules. A conditional approval request has been filed and it does eliminate all staff comments. So I have no comments. This was not placed on your consent agenda because there has been testimony. That testimony has generally been favorable, and it looks like that there is also one informational note to bring to your attention in the proposal, and this is on page 8 of the PDF. It's also page 8 of the conditional approval request. So there was some legislation that came through last session, SB 265. It is effective as of July 26th this year. It is included in your attachments. So just pointing out to you that the language that is, the highlighted language there has been submitted to deal with that legislation. And like I said, there's probably some folks here looking to testify. So those were all my comments.
Okay. Tell us who you are.
My name is Eric Wind. I'm an attorney advisor for the Public Utilities Commission, and I'd be happy to answer any questions that the committee may have.
Questions from the committee? And Cliff and company, are you objecting to this rule?
Move to approve.
Motion by McGuire, second by Hatch. Any discussion? All those in favor? Aye. Any opposed? Thank you. Department of Safety.
Okay, yes, sir. So we realized this morning that there is one document that is missing from your in your attachments.
Which is the
And
letter.
it looks like you should already have a hard copy of that document. It was the agency's cover letter to the preliminary objection response. So these are the safety ignition lock program rules. At the July 21st meeting, the committee voted to enter a preliminary objection to these rules based on its determination that the department doesn't have either federal or state authority to have the interlock devices set at an alcohol set point of 0.020. RSA 265A37 establishes the alcohol concentration level that results in a violation, but the statute doesn't say what that set point should be, the baseline, if you will. RSA 25943A, in its definition for ignition interlock device, says that the device prevents the vehicle from starting unless the person provides a breath sample with a concentration of alcohol that is below a preset level. But again, the statute doesn't say what that preset level is. Testimony from the department indicated that 0.020 is an industry standard. There was some testimony from the industry that initially wanted that set point changed. I think from the last meeting, the department had testified to the fact that the industry was okay with that set point level. The department also stressed that there are two types of drivers, the over 21 and under 21, and so that does impact that as well. But again, you have the preliminary objection response in front of you and the agency's cover letter, and they've made no changes as a result of any of the back and forth testimony that we've had previously. So with that, that's all I had to say on this proposal.
Good morning. Turn your mic on.
Marta Montagnani for the Department of Safety, Chief Legal Counsel. I've got with me Deputy Director of the DMV, Michael Todd. I've got Financial Responsibility Supervisor Bob Keller, and also Captain Chris Vetter from the State Police. I know that in our multiple meetings about these rules, there have been several questions from enforcement to the actual program. I think we're just here to answer any questions you may have. One of the outstanding questions that Representative McGuire had that I couldn't answer was it the deviation for the device, and we've since learned it's 0.005. Or we want to share that, rather, sorry.
Thank you. Questions from the committee?
Well, we had the colloquy the last time was that there seems to be an industry standard, but there was a conflict between the practice of using this device, between what is the warning and so forth. I don't have to go through the whole discussion. We all remember that. And how have you resolved it so that we have something that both complies with the industry standard, but also does not put the public in jeopardy in advance of where the actual statutory red line is?
So we haven't changed the proposal, Representative, but I think that what the DMV will say is that the industry standard and the testimony or the written testimony provided by the industry was the recommendation to have an alcohol set point of 0.020 and to distinguish that from the violation, which is in statute. But even in the violation, what the statute says is that anything greater than 0.025 is a violation. It doesn't say that that's the preset level of the device.
Tim?
So, well, I'm trying to understand. We have a statutory requirement that basically you're against you violate the law if you have a 0.025 and you attempt to use the interlock device. Is that correct?
Over 0.025.
Over 0.025.
Yeah.
However, the state, by installing the interlock system and setting a set point at a 0.020, is taking action against an individual that hasn't violated law by not letting them start their car and get to wherever they're going. So I'm trying to understand where the authority is to allow them not to act when the statutory authority is a 0.025 or greater.
So the authority is that in the definition of an ignition interlock device, the device is set to have a preset level that's going to stop the car from starting. It's not a violation at a 0.020.
Representative Lang and committee members, if I may. I'm Mike Todd. I'm the Deputy Director for the Division of Motor Vehicles. And I understand the concern that's being raised, and I'd just like to provide a comment on what the public policy implications are. The intention of the program is behavior modification. The intention of the program is to modify behavior of someone who's shown poor judgment when they are consuming alcohol and making the decision to drive or not to drive. The intention of the program is to help them develop that better behavior. And if they do not participate, in many, if not most cases, if the individual is not participating in the program, they would not be able to drive at all per the court order. So the reason the set level is at 0.020 is because it gives them an opportunity to learn, to make better choices, to have better judgment without incurring that violation that they would incur if they were above 0.025. The goal is to help people get back on their feet, get back into making those responsible judgments so they can drive without concern for public safety. And that's the public policy intent of this program. And that's, I don't have anything else. Any questions?
Senator Gray.
I just have a comment on the statement. That would be a perfect statement if we were here, sitting as a body looking at changing statute. But right now, the statute says one thing, the rule says another thing, and I can't vote for it. Okay? Thank you.
Mr. Chair, I think they are within the statute as it was read. And if we have concerns with that, it's up to the person that has the concern to change the statute. Because again, this is where I have this thing about relative terms or not being explicit. The statute is not explicit. That's our bad. So I think they're within their realm of authority, and I would propose an approval. Thank you, Mr. Chair.
So I guess, Mr. Chair, I'm struggling with the idea that it'd be like stopping a car. We have a 70-mile-an-hour speed limit, but we stop them at 60 because we were worried that they might go over 70. And they have no authority to do that, right? Because they're within the law. So my concern is that we'd be approving something just to that effect is where, well, I don't want anybody going over 70, nor do I want anybody drinking while driving. We have statutory authority that's set, and we're setting a lower standard by rules, which I don't think would be allowed.
If I may, Mr. Chair, I understand the concern, and I do not disagree with it, but our job here is not to legislate. Our job in JELCAR is to assure that the legislative intent is followed, and the intent is in the written word, and there's not a defined limit. So they're within what we legislated. So if we want to change that, we have to do a legislative change. That's why I proposed an approval. Thank you, Mr. Chair.
Representative McGuire.
Yes, thank you. I agree with Representative Lang that this imposes for whatever good reason it may be, it imposes a restriction on people that is beyond the statutory limit. It may be good, good training and all that, but if you're at 0.020 or 0.0201, you are not committing a crime. And you should not be penalized by not being able to drive.
I'm sorry.
Under the authority of
Yeah.
the crime. If you're talking about creating good habits and all that, yes, but I don't think that's appropriate.
If I may, Mr. Chair, it was pointed out, and I hate to belabor this.
Let the department.
Oh, I'm sorry.
Thank you, Mr. Chairman. So, Representative McGuire, they've already been these individuals have already been convicted of a crime. That's why they're required to participate in the program. If they choose not to participate in the program, they don't drive. They're not able to drive at all. And so, because they're already suspended, this program allows them to actually transport themselves. Where if the program didn't exist, they would not be able to do so. So I think I just want to encourage the committee to understand that they're already suspended. These individuals already have a suspended driving privilege. We're not removing a privilege that that's been restored. This program is giving them the opportunity to get back on their feet. Thank you.
Again, Mr. Chair, I don't object to the program. My objection is that the statutory authority that we set for the program is a 0.025. And we're at a different they're setting conditions below that statutory requirement. So I'm just struggling with the idea of we're imposing a rule that, or we're setting a new term and condition of a violation. Even if you're not being charged criminally or in court, it's just a different rule than what we set in statute, which is a 0.025. And we're penalizing somebody below that level. I'll go back to my example of a speeding ticket. We're stopping somebody for 60 in a 70 zone when they didn't break the law.
May I respond?
Yes.
Thank you, Mr. Chairman. So Representative Lang, I just, again, I would like to discuss that these individuals, they have broken the law. They've been convicted of breaking the law. And in the example you gave, this is a person who would have a proven track record of speeding, breaking the speed limit, and it's a danger to themselves and to other people on the road. And the program exists to change that behavior. And so what this allows them to do is to change the behavior and learn that new judgment without incurring a new violation. And we believe that is what is safest for the individuals who are on the road, the children, the women, the mothers, the daughters, the wives, the husbands who are out on the road, to help change that behavior. And that's what the prior legislative intent was. That's what the NHTSA standard, the NHTSA suggestion is, and that's what we're trying to do here. Thank you.
Yes, I move we approve the rule or the objection response, and with the request that the department seek statutory authority for their 0.020 set point.
We would be very happy to do that. Thank you very much, Representative McGuire.
Motion by McGuire, second by Hatch. Discussion? I guess this,
I think we ought to go forward, Mr. Chair.
yep. Going with a roll call vote. Senator Gray.
No.
Senator Prentice.
Yes.
Senator Ward.
Nope.
Somebody write these down. The chair votes yes. Representative McGuire. Representative Hatch.
Yes.
Representative Schmidt.
Yes.
Representative Lang.
No.
Representative Burstein.
No.
Representative Sherrill.
Yes.
Did somebody write down?
Is it for the roll? Do you have the roll? 6-4 with 6.
6-4 approval.
Okay, motion's approved.
Thank you very much, committee.
Department of Health and Human Services.
Yes, sir. Before we get into the proposal, the agency has late filed a conditional approval request. So if we could get the committee first to a vote to accept that late filing, then we'll jump into the proposal.
Have a motion to allow the conditional approval.
Second.
Motion by McGuire, second by Hatch. All those in favor? Any opposed?
Okay, so this proposal, it makes changes for the process for involuntary emergency admission. Like I said, the agency has filed a conditional approval request, but there's still quite a lot of substantive issues that remain. Some of them may need legislation to address. The emergency rules have expired. They expired just a few days ago. The final proposal was filed for the August meeting. However, due to multiple OLS staff illnesses, the proposal was postponed to this meeting, and the rules subsequently have expired for a few days. The committee may have some questions about that. And as a way of background, in May of last year, the Supreme Court issued an opinion for a court case, Jane Doe versus Commissioner of the Department of Health and Human Services in Merrimack Court. And the court analyzed several statutes, 135C31, and the bottom line held that a person is entitled to a probable cause hearing within 3 days of the completion of a certificate, not the person's delivery to the designated receiving facility or the completion of the petition. There's some ongoing litigation, and potentially there'll be some legislative changes this session, so the department is probably going to be in rulemaking several times. I think the main comment that I have, without going through all of the comments, is that the proposal doesn't accurately use the terms petition and certificate. And that is problematic because they don't represent the same thing. If you look at the judiciary's form on the first page, the instructions to the petitioner, it lays out what all the elements are for the form, what represents the petition, what represents the certificate, what represents the witness statements, and then the physical and mental evaluation, the results of those. According to the statute, the 3-day clock for the probable cause hearing attaches upon the completion of the certificate and not petition. And then the mental and physical health evaluations must occur either simultaneously as the petition or must occur within 3 days prior to the completion of the certificate. So it's kind of very important to make sure that that is laid out correctly in the rule. Right now, the rule is sort of ambiguous. At times, it's referring to the petition and certificate when it means just the form, the form in its entirety. Other times it's referring to it when it really means either the petition or the certificate. So that's like my overall concern with the rule. As I said, there's a lot of going on. Chief Legal Counsel isn't present today, so I'm unsure of how much we can actually get through with all the comments, but that's a high-level overview. There's also going to be quite a few people probably here to submit some testimony. Testimony has been linked, and you should have it from NAMI, from the New Hampshire Hospital Association, and from the ACLU. And with that, I'll turn it over.
Go ahead.
Good morning, Allison Radmay, Administrator of the Administrative Rules Unit here for the Department of Health and Human Services. I do want to touch on the interchanging petition certificate language. We did, in our conditional approval, define petition and certificate. We did add that in as the whole form provided by the court, which is entitled as a whole petition and certificate for involuntary emergency admission. There's various breakdowns within the form, but as a whole, it is the petition and certificate that is now defined and outlined accordingly throughout what pages need to be used for what in the rule. And then just kind of going on, HEM 614 was created to identify and address the process to ensure those who are determined to need an involuntary emergency admission from a certifying provider that they receive probable cause hearing by the courts to determine whether the IEA is appropriate within 3 days of the completion of the petition certificate. This rule is important for several reasons to get it on the books. We do understand that it is not perfect, but we are willing to work and we plan on working with our stakeholders and moving it forward. At this point, as you know, this was an emergency rule that the department had filed in March of 2022. We did intend to have it heard at the August GELCAR. We received comments back on this from attorney staff on Friday, this past Friday, and we tried to turn around some changes as quickly as possible. Again, we know this is an ongoing working session that needs to happen behind the scenes with our partners and stakeholders, and we are willing to do that. But we do hope that we can get something on the books that we have to work on, so we go without, or so we do not go without any rule at this time. Thank you.
And
Good morning. I'm Attorney Steve Bunker, counsel for New Hampshire Hospital.
okay. Okay.
Okay, so I mean, there are a few options. The rules have expired. So I think probably from a practical standpoint, if this isn't approved, the agency might be faced with doing an emergency rule again so that they can have something in effective. They can do that as long as it's not the same emergency rule as what just was filed and expired. You could preliminary object and give them time to work through this proposal, but again, the rules are expired, so they're operating without rules at this point. You may have some questions about that. You could conditionally approve. I think those are your options right now.
So at what point are you in your discussions and you're working on making this a better rule?
I think, I apologize. It's continuous at this point. Like I said, we received comments.
Continue over a year or a day or,
Oh no,
let's
we're
be
ready
specific.
to immediately go back into rulemaking and start working with our stakeholders. Like I said, we understand.
Monday?
Happy to start working. Yes.
Okay. Because, it's expired because nothing was happening, right? So,
Yes, we understand it's expired and nothing has happened within those 4 days. And depending on the outcome today is how we would have.
okay.
Yes.
I have one card from Ms. Thunberg who wishes to speak. So let's let her hear what she has to say on behalf of the Hospital Association.
For the record, my name is Kathy Pizarro Thunberg, Executive Vice President, New Hampshire Hospital Association. You do have a copy of our testimony for this committee in your packet. I just want to speak briefly to some of the high points. I'm not going to go over the 9 pages that I submitted. Our testimony is really centered around the universal fact that patients who are deemed to be a harm to themselves or others should be afforded the protections of the state's mental health system through the IEA process. Having clear and transparent rules for IEAs is utmost importance because there really hasn't been any in place. So I agree with the department that it's important to have these rules in place. However, the rules as written and presented to you are inconsistent and contrary to current state law, particularly RSA 135C29I, which says that upon completion of an IEA certificate, the patient must be immediately transferred to a designated receiving facility or New Hampshire hospital. In addition, as noted by the Counsel for GELCAR, both the New Hampshire Supreme Court and U.S. District Court for the District of New Hampshire both have held that involuntary emergency admissions occur when the IEA certificate is completed, and upon completion, the patient must be immediately transferred. Unfortunately, there's many areas in the rule that is contrary to that. In particular, there's just like one example, one section that references physical exams to be completed within 3 days and mental health exams to be completed within 3 days. Fortunately, the certificate has to be signed with those 2 exams completed. So the rules are kind of contrary, saying that the exams can happen, within 3 days, but yet the certificate has to be completed with that done. So that needs to be cleaned up. That's just one example.
Okay,
of
so your
contrary.
recommendation, so that we can accept this rule, would be to do what?
Unfortunately, we do object to the rules as they're drafted. I don't know. I guess it would be up to the GELCAR Council to be able to tell you what to do as far as how to
Okay,
fix
so
these
you
issues.
object to the rule?
Yes.
Okay, thank you. Shields?
Thank you, Mr. Chairman. Gilles Bissonnette on behalf of the ACLU of New Hampshire. I'm the legal director there. I'm also here on behalf of the class plaintiffs in a lawsuit that was filed with respect to the due process rights of individuals who are involuntarily detained. Certainly the rules here are better than the process that existed for the past decade, but we still do have some concerns with respect to the draft. I haven't seen what was filed conditionally on Friday. But do want to thank DHHS, though. Some of our feedback during the process over July was accepted, but there's still some concerns, principally actually for the reason that committee counsel raised with respect to the conflation between petition and certificate, which seems like technical. Why would that matter? And it actually really matters with respect to timing, because timing here is critical for individuals who are being involuntarily detained. They're entitled to prompt due process. And so those terminology issues potentially, in our view, if not clarified, the rules could then be construed to possibly extend for 3 additional days involuntary detention. I won't get into the weeds of why that's the case. It's drawn out, explained in our testimony. And the last couple things I'll say, I won't get into the weeds. We do have some additional recommendations. We think that would make the rules better, more consistent with providing due process rights for the individuals who are here, because really at its core, what we're dealing with are individuals who may not be going through crisis, who are being detained against their will. And in our view, it's absolutely critical that they receive all the due process protections that they're entitled to. And so we list those out, which would include providing some protections in the event that there's a rescission of an IEA certificate. It would also provide some protections with respect to the venue of due process hearings as to where they occur, and making sure there's clarity as to who is required to actually file the petition. So We would just recommend some further work with respect to these rules. We're happy to be part of that process. We provided comment back in July. Thank DHHS for its work, and I'm happy to, again, to continue with the process. Thank you.
Any questions from the committee? Bill?
Thank you, Mr. Chair. Was these concerns presented to the department during the public hearing process of the rulemaking?
Yeah, yes, they were. With one clarification, Section 3 in our testimony, which has to do with rescissions, I don't think it's either Section 3 or Section 4 that we have subsequently added. I don't remember which. I could let you know if that's okay. Most of it was presented earlier, yes. Thank you.
Yes, do you have a recommendation for what we should do? Because do you want to have no rules at all? Do you want us to adopt these rules however faulty they may be?
That's a hard question. I think with respect to the definitional problems, petition, certificate, that just needs to be fixed in my view. I don't know that I wholesale object to the rules because, again, I think on balance, this is better than what we didn't have anything before. So that is something that I'm kind of struggling with, to be honest. I'm sorry I don't have a direct answer. That's probably the best I can do at the moment.
Can we expect something by our continued meeting?
Initial proposal. I would have to touch base with Chief Legal Officer St. Cyr when she gets back from traveling. She's traveling for work right now, so she cannot be here today. But once she gets back into the office, I think we can come in out.
Could I also be clear? I'm sorry, Mr. Chairman. I don't want to interrupt. I am strictly basing my testimony on the version from July 26th. I do not know whether in the subsequent filing changes were made consistent with our public comment. So I just wanted to make that abundantly clear. I have not seen any new version. So
I can get a conditional approval request copy out to the stakeholders.
So it's certainly possible that perhaps some of these issues were rectified. I haven't seen it. I'm sorry.
Is that conditional approval request on the?
It is linked. Yes, you do have it. Yes, ma'am.
It is on the jail car
website.
packet's website.
Oh, I apologize.
But I can't read 16 pages.
I'm
right
sorry.
away.
My testimony is to be abundantly clear based on the July 26 version. So I just want to clarify that. I'm sorry.
So for patients now, what we have grants them protection.
Yes, I think that's right. It provides currently unlike what was happening before, it seems that due process hearings are actually now being provided in some instances, even when individuals are in emergency rooms, which was not happening before. Right. Due process was provided once they went to the designated receiving facility, often New Hampshire Hospital, but because of the wait list, that could have been weeks at a time. So there are hearings happening. Now, actually, I'm not going to get into the details of this, but I have to be clear for the record that we actually don't think the way these hearings are currently conducted are fully consistent with due process. They're telephonic, so the courts can't meaningfully, in our view, engage with the patients. This rule is not really addressing that, though, right? It's just addressing when these hearings occur. So to answer your question more directly, there are hearings happening now. They weren't happening before. We have separate concerns that we'll raise at another forum.
With that understanding, I would like to move we accept the conditional approval response with the additional consideration that the department enter into rulemaking immediately to clear up the distinction between the petition and the certificate.
The second includes
further comments. Discussion?
They're going back to work on Monday.
That's what we're hoping.
Telling us on behalf of the department, you're going back to work on Monday.
We're going back to work on Monday.
Okay,
Seeing no other discussion, all those in favor?
Aye.
Opposed? Immunization registry rules. And I didn't.
Good morning.
Good morning.
Ready? Thank
No.
you. So this proposal is an interim rule 2022-5 submitted by the department and has to do with the immunization exemption for schools based on religious reason, as well as the process for withdrawal from the immunization registry. This interim rule comes from two changes to the statute. One was HB 1035, which was chaptered as Law 55 in the laws of 2022. This particular change in the statute removed the requirement that a exemption for religious reasons to a school be notarized. The proposed rule does remove that requirement, that notarization requirement for religious exemption. And then the second statute amendment comes from HB 1487, which is Chapter 307 of the laws of 2022. That particular change in the statute requires that a patient or a patient's guardian, if the patient is a minor, may withdraw from participation in the immunization registry by either having a healthcare provider sign off on the form or for the form to be notarized. That was also changed in the rule. And then with regard to staff comments, we did have a couple unclear legislative intent comments. However, the agency did submit a conditional approval request which addressed all of the staff comments. So the only remaining address those unclear legislative intent comments. The remaining staff comments are all notes to JLCAR for pointing out the changes, the statutory changes, as well as pointing out to the committee that pursuant to RSA 141C 2, the commissioner does have the authority to design the content of all forms via the RSA 541A process, as the rules do include some language that is included on their forms, specifically regarding HP 301.13, which is the exemption form. They include the language discussing the risks of required vaccinations, that they may change their decision and submit evidence of vaccination to the school at any time, as well as advising that in the event of an outbreak of vaccine preventable disease, an exempt student shall be excluded from school attendance in accordance with RSA 141C 20D, which is what the statutory language is. And additionally, with regard to the withdrawal from the registry, once again, the commissioner does have the ability to design that form and has included the language that is on the form in the rule. So at this time, once again, the committee's three options are to approve the rule, conditionally approve the rule if the committee feels additional changes are made, or to do a preliminary objection, though, as I stated at this time, staff doesn't have any substantive comments.
Thank you. Before the department answers the staff's comments, I would like you to address the issue of your having posted 2 versions of this form on your website without any approval, which is definitely beyond your scope of authority. Could you explain that?
Thank you for the question, Representative McGuire. In order to be, oh, sorry, my name is Abby Rogers. I'm the Legislative Liaison for the Division of Public Health Services. In regard to the form was redesigned as a result of HB 1035 being signed into law. The effective date of that legislation was July 19th. The department felt that, there were many vaccine-related bills over the course of the session, and really wanted to be very responsive to having a ability for people who wanted to choose to have a religious exemption for their child have this form available before the start of the school year. So we updated the form and posted it not as a required form but as a suggested form, and realized that we may have jumped the gun a little bit by posting it without having the form reviewed by GELCAR. So that was why the form was posted, and then we did take that down. And now we're here to go through the process and have the
And
form
I understand
reviewed.
there's a different version of it posted again.
There is a form posted right now. We heard there were concerns about certain parts of this form that we're here to discuss today, and have a basic form for parents to access, which they can use if they would like to submit that to the school. Otherwise, they can use a letter as well.
Madam Chair, if I may.
Yes,
So,
Representative.
thank you. 1035 was my bill. So I want to be clear. So we put up a form against 540 that was in violation of 541. We took that form down. Then we put up another form, knowing that we're still one was dated in July now, and we have another one dated in August. And before us, we have another form dated in September. And I guess my question is how did that happen when we asked earlier last month? I mean, I'm concerned because this bill was signed into law in May. So we had plenty of time either for some sort of interim rule or anything else, and nothing was done. It was signed into law. It was passed by the legislature weeks before that. So you knew it was coming. And no rulemaking, no interim rulemaking, nothing was done. We just outright violated 541A by posting requirements. And I'm just concerned by that and where else that might be occurring.
You also didn't even bother to try an expedited revision to forms, which is a process for updating a form in some cases. And so you're confusing people who are looking for it on your website, because that is, whether you say it's a suggestion or not, it's assumed to be required since the vaccinations are required. And you're changing it without any oversight or any authority, and I am extremely disappointed that a major department like HHS doesn't understand that a form has the force and effect of law, and people will obey it, whether it's correct or not, and whether or not you've made changes to it without any oversight. I'm severely concerned about that.
Thank you for that. We appreciate that. And again, we had many pieces of legislation that were going through rulemaking in regard to vaccination, 1487 and also HB 1035. We also have HB 1606, which is also Representative Lang's bill, which has an effective date of July 1st, 2023. Those are all three related to withdrawal of the vaccine registry. We had looked at those holistically and trying to move those forward. We wanted to move these two forward in interim rule. Again, the form was posted, and again, we weren't trying to undermine anyone's authority. We were, in hindsight, looking to try to make it easier for those folks to use that form to exempt their children if they chose to, using the religious exemption form. So we're here today to talk about the forms that we have put forward. We hope that we could discuss those and take a look at those. Thank you.
One last comment, Madam Chair.
Yes,
'Cause
Representative
I
Lang.
heard something I want to be clear. So currently, it's DHHS position that the current form, which is dated August 22, that's currently on your yeah, I think that's August
So that's
22.
not been approved.
Well, I understand that. I understand that, but I'm just trying to clarify something they said to make sure I understood it right. Use the current form that is up there, you're saying is a suggestion, not a requirement, that parents can write their own, and that's completely legal and completely okay.
Yeah.
Hello, my name is Anne Marie Riccieri. I'm the Immunization Section Chief. So prior to this proposed act to put the form into administrative rule, the form has not been part of administrative rule. So the department felt as though it was the best option to be able to simply take the old form that was original and remove that notary requirement. So we removed that notary signature line, and that's the current form that you see posted on the website.
Madam Chair, I'm not sure if they have more they want to say before I have some more questions. So I
Yes,
give them the
please.
opportunity to speak because we kind of jumped right in.
Hello, Allison Radmay, sorry, administrator of the Administrative Rules Unit for the Department of Health and Human Services. And we are here again to move these new forms forward. I did want to just touch base really quick on the expedited process versus the interim rule process. We decided to do the interim rule process opposed to the expedited form process because these new forms, with removing the notary requirement, that was actually listed in our rule. And that's something that we can't change in that process, so we moved it forward in this way instead. But with that, we will open to any questions that you may have.
Representative Lang?
Oh, absolutely. Thank you. So I'm looking at, as part of our packet, we were given the old version of 141C 20-C, which is the exemption language. And under exemption language 2, which deals with the religious exemption, that statute specifically says a parent or legal guardian objects to immunization because of religious beliefs, the parent or legal guardian shall sign, and we've struck the word notarized, shall sign a form stating that the child has not been immunized because of religious beliefs. So that's the statute as it exists, I believe, as it's been modified. And are we in agreement with that? That's the statute. Great. So as I look at that, and then I look at your new form, and I look at your new rule, my question comes down within right in your opening line in section E, in accordance with RSA 141C:20C, which is the exemption statute, an admitting official, which I assume means a school, shall exempt a child from a immunization requirement. But then you go on and say only if, and you start adding new conditions for a religious exemption in saying that they have to acknowledge risk, they have to acknowledge disease, vaccines prevent disease, they have to acknowledge the transmission of disease, none of which is in the statute, and which is a condition of religious exemption requirement. I'll go on further and say that addition on the new form that you're proposing, you now require parents, again, because they're required to submit this form, you're requiring parents to disclose medical information to you. Again, not required by statute anywhere in the exemption statute. You're asking them that which ones do you have and which ones you are claiming the exemption for. Again, not authorized by statute anywhere that I can see that you start collecting another database that has immunizations in it. So I'm concerned about those issues, that we're setting new requirements that aren't authorized by law in order to grant a religious exemption. And then additionally, as I look through this rule, I'm concerned as we get down on page 2 and we're looking at that second line where it says, I understand that it's my responsibility to inform my healthcare providers of any decision to withdraw from the registry so that no future immunizations, vaccination information is reported to DHHS. And yet the legislative intent was clear in 1606. And while I understand it hasn't gone into into statute. The legislation is extremely clear when it says that no patient or personal data such as name, address, date of birth, immunization, or vaccine information shall be entered into the registry without explicit written or electronic consent from the patient. Doesn't put an obligation on the patient to go tell the provider, I don't want this. What it makes the obligation is that the state has a requirement to make sure that it has some sort of consent to take the data. So I'm concerned now that we're shifting, the legislative intent was clear in 1606. The obligation is that you have permission to take the data. And now we're pushing the obligation back on the patient, which is not the legislative intent and what our legislature believes. So I'm really concerned that, again, we're collecting medical data that's not authorized. That would be in violation of our Constitution, where we're collecting data without consent of the patient, and they're forced to give consent. It's coercion. We force them into giving consent. Otherwise, their kid can't go to school unless they fill out this form giving medical data. So I'm really concerned by this rule, that it violates all kinds of A practice and B. So my question is, how do we get past that? What is your authority to set a new standard? What is your authority now to shift the consent back to the patient instead of the state, who has the obligation to collect the data, to have consent to collect data?
Thank you for the questions, Representative Lang. I think I could shed a little bit of light on why some of these things were included in the suggested form that you have here today for the religious exemption. The listing of the immunizations that the parent or guardian is suggesting that they would like to exempt their child from. First of all, to be clear, that this form goes to the school nurse. This does not come back to the department. This is a department form that would be used for the parent. It would go to the school nurse. So this list of vaccinations is for the use of the school nurse. If there is some parents opt out from all vaccines for religious exemption, others might just pick one for a specific reason. The school nurse is the person who is in charge of making sure that the school community is healthy. If there should be an outbreak of communicable disease that's preventable by immunization per requirement, and a child is exempt and there's an outbreak, it's for that child's safety that the school nurse know which vaccination that child does not have in case there is an outbreak. I think it was mentioned before that under RSA 141C20D, if there is an outbreak and a child is not vaccinated due to religious reasons or perhaps medical reasons, they would be exempt from school for their safety. That's why that was included there. Many states do opt to have that as a listing to help the school identify if in the case of an outbreak. So that's the kind of rationale for adding that. I would say that the additional questions on the bottom of the form is, I understand the risk of contracting the disease. Those questions are, those are public health statements that help someone who is opting, their right to opt out for a religious exemption, to just be reminded why vaccine and vaccination is important for community and school. And why there are some students at school that cannot have vaccine due to neurological conditions, due to immunocompromised diseases. And so this is just reminding folks that there are other people in the school that may benefit from people being vaccinated. Certainly, you're right not to have your child vaccinated, but it's a reminder for the broader community perspective for public health. And that's why those things were included on this form. And I can. 1606 I know is becoming effective July 1st, 2023. We have done some initial meetings internally with the department and with stakeholders to go over the language for those potential rules. And we are not too far along with that yet, but certainly those concerns you express about collecting data and how this is written is certainly is very valuable feedback as we continue with that process. For example, if I could share a little bit just about your question about 1487, I understand the withdrawal from the participation in the registry, all of those, so I understand section of the form, if you will. So previous to the statute change in HB 1487, previously to that bill passing and becoming effective, to withdraw from the registry, a patient or a patient's legal guardian, if the patient was a minor, would need a healthcare provider signature. That bill has changed the statute. So now you can have a healthcare provider if you choose to sign your form, or you can have a notary. These questions, we feel, if you were going the notary route, would not be something that usually if you were go to a healthcare provider, they would go on over this with you as an educational piece before you withdrew your information. These were included in the form primarily to, if you choose the notary option, then you have that little piece of education that you wouldn't get if you had an opportunity to speak with your healthcare provider about withdrawal. So I hope I was able to answer some of those questions for you.
Any other questions from the committee?
So, ma'am, if I may, ma'am, Madam Chair.
One more question, please.
So absolutely. I'm trying to, again, understand the statutory authorization to include new conditions. Because again, my concern, I'll be honest with you, I'm pretty sure I'm okay with the new form. You just put up that stated August 22. I would have no objection to that form. It's a clean, simple form that removes the notary requirement that just says, I'm requesting a religious exemption. I'm done. And that's it. It's the collection of the new data that I'm trying to understand where the authority comes from. Again, that doesn't exist in statute, right? Under that 20C statute, doesn't have an obligation to acknowledge any of this. It just strictly says that you request one. And so I guess I'd have no objection if you were being present, bringing forward that form you just put on the website yesterday or whatever it was. But this other data, I'm still trying to struggle with. I understand the public health concern that you may have, but we're collecting data, and whether it's you or the school, that's still the government. That's still state agencies requiring data. And I don't get where we have that authority to require the citizen provide that data, not by statute. So
Representative Lang, the last paragraph, which says that in the outbreak of vaccine preventable disease, exempt student shall be excluded from school attendance. And if that's specifically in statute, so they need to know that you have not received the measles vaccine in case there's a measles outbreak, and then they do not allow you to attend school.
So again,
That is specifically in RSA 141C20D.
Understood, Madam Chair, and that's why this is the new form they just posted yesterday.
Okay.
And the new form is very clean. It's again, this is the whole form as compared to this form, right?
Yes.
Simple little statement and paragraph, a comment. And on the new form, it says, it has that warning. It just says, the administration immunization agents conflicts with my religious beliefs, with the religious beliefs of the parent or legal guardian as student listed above. I understand that in the event of an outbreak, the vaccine preventable disease in my child's school or child care facility, state health director may exclude my child from the school or healthcare facility for their own protection. This exclusion will last into the incubation period from the last identified case of the communicable disease is passed. So that's informational, right? You're notifying. This one, as far as I'm concerned, especially as a former prosecutor, has potential for some overzealous prosecutor to go after a parent because you're forcing a parent to acknowledge that you're putting your child at risk. And I could easily see a potential overzealous prosecutor when your child gets the measles deciding to charge you with neglect because you were warned that this could happen and you did it anyway, and your child's now sick. So I'm okay with this form that they just posted, which is informational and warns the parents that if you choose to do this, your child may be excluded from school. The other one I think is problematic in forcing our parents to provide information they may not want to provide, and you don't have a choice.
Thank you. Do you have a further comment?
Yes, ma'am. Thank you. I do want to say that basic language that is on that new form that was posted yesterday, that was one of the legislative intent comments that were provided by OLS for us to change that may to shall. So these children shall be exempt or excluded from school. So that actually was changed within the rule text. And OLS staff did point out their third comment, first on the left, that pursuant to RSA 141-C Roman 2, the commissioner has authority to design the content of all forms via RSA 541A process with respect to these issues. And that's where you have these understandings coming in on these new forms.
Yes, okay, so if you have the authority to include that, we have the authority to object to it, correct? You can only adopt that if it is approved by the committee.
Correct. And I was just pointing that we did have the authority to add
Thank
those.
you.
And I'm sorry, I just want to edit that. It's RSA 141C6, Roman numeral 2. The 6 was omitted from the comment. So I just wanted to make clear that that is the statute that they're referring to. And yes, it does say that the commissioner has the ability to design the content of all forms required for reporting communicable diseases. And I also wanted to point out that RSA 141C4, the duties of the commissioner shall, in paragraph 3, I apologize, hold on. That, they has the duties to establish, maintain, suspend, isolation, and quarantine to prevent the spread of communicable diseases. Once again, tying into that RSA 141C D in exempting or refuse having students not come to school if there is an outbreak of a certain disease that they're not vaccinated for. So I just wanted to bring that to the committee's attention as well. And also in RSA 141C4, in paragraph 7, the commissioner has a duty to educate the public relative to the cause, prevention, and treatment of communicable disease, and relative to the provisions of this chapter and its rules regarding reporting, investigation, examination, treatment, and care.
Thank you. Attorney Morrell?
3 points. Regarding the may versus shall issue, staff did raise the point that the rule said may, but statute specifically says it shall be, the students shall be prevented from attending. Regarding Representative Lang's comments about 1606, I would agree to the extent that, yes, the department's absolutely going to need to go through rulemaking to make accommodations for the requirements of that bill. However, this interim rule is only in effect for 180 days, and 1606 doesn't take effect until next July. So the department would have time to adjust for 1606 and could in fact go through the whole rulemaking process and have the rule ready on the same date that 1606 goes into place.
In fact,
And-
they need to go through the whole
Okay.
rulemaking process.
And lastly, regarding the extra information that's now in the form and in the rule regarding I understand, House Bill 1487 has fairly specific language about requiring acknowledgements by the parents.
Okay, thank you.
Thank you.
Oh, I just had a quick comment to make on 1606. There's no, even though it's not effective until next year, there's no retroactive requirement that the department remove the data, the personal data that's already in the registry. I
Yes,
just want to,
that's well
is that
known.
right?
Okay.
Madam Chair, can I just ask, I guess I just have a question about, does the agency have the right to add, and I guess this is for staff, when I was talking about that section E where it says only if, and then it has additional requirements for acknowledgement of data, and
The staff has said that the department not only has the authority, they have the duty to inform and get acknowledgements. If I understood you correctly, that's what you said, is that it is the department's duty. And if you don't like it, we've got to clean, there's some statutes we should clean up, I would say. Any other comments from the department? We do have some public testimony. Representative Cushman?
Thank you. Thank you, Madam Chair. Leah Cushman, representing Ware and Deering. I serve on the House Health, Human Services, and Elderly Affairs Committee and was a part of the process of amending this bill and can speak to the legislative intent. The intent was to strictly remove the notary requirement. And I believe that this form that
is being proposed in this interim administrative rule proposal steps well outside the bounds.
Is that, which version of the form are we talking about?
The
Because
one
there
that's
appear to
in
be
the
several.
proposed rule. The one with the, I understand the risk of contracting the disease. I understand.
Is, if you have, if, that's, excuse me for interrupting, but is that the rule, that the form that you are, the department is proposing to bring forward?
Yes.
Which one?
It is the one that
I'm,
has
excuse
the
me, I'm asking the
boxes for.
department.
I'm sorry, it is the one that has the understandings on it.
That is the rule you intend to bring forward. Okay, thank you. We were confused by the shortcut.
Yes.
My mistake.
So I have some issues with this form because I think it's well outside of the bounds of the legislative intent. And while they do have the right to require acknowledgements, this makes it so that in order to be granted an exemption, they must, acknowledge these certain things. And that is not outlined in the statute. The statute is very clear. It's one sentence. The the student, child has not been immunized because of religious beliefs, period. That's it. That's all the form should say. The old form that they had did not require all of these things. And the only thing that changed in the statute was striking the word notarized. So I don't understand the logical leap there where, well, we got rid of the notarization requirement and now we can require all of these acknowledgements. It doesn't add up. So I think that if the form is just a suggested form and that parents can make their own, that should be stated somewhere. I think that this form that's proposed should be rejected based on those extra requirements. It should not feature the word request or certificate either, because it's not really a request. You are exerting your right to an exemption, and it should just state that, my child is exempt based on our sincere religious beliefs. It shouldn't require a listing of vaccinations. I see that as an intimidation tactic. Parents will fear religious inquisition or scrutiny based on having to procure that information, and that there can be religious reasons to object to one vaccination and not others. Some are made through research on aborted fetal cells, some are not. Some are grown in monkey kidney cells, some are not. So there are different reasons that parents may object for religious beliefs to different vaccinations. And under the statute, it's not required for them to disclose that. School nurses, when they receive medical records, they can request the immunization records. And if they're not a complete immunization record, there's some missing, they can note that when they receive them along with the exemption. It shouldn't be on this form as a requirement to exert that right to an exemption. There's also no need for an address, phone number, grade, all of that. The schools already have that. School nurse has that information. All that should really be required is name and maybe date of birth. And lastly, the acknowledgement of risk to yourself and other students, that's an intimidation tactic as well. Those statements are not only self-incriminating, but they also the risk of contracting or transmitting a communicable disease is usually not relevant to the religious reasons and someone's sincere religious beliefs for objecting to a vaccination. So again, that's totally inappropriate, and there's no statutory authority to add those statements to the religious exemption form, especially as a requirement. So either they need to be removed, or it needs to be very clear on the form that it's just a suggested form and that parents can submit their own form. That's just the very simplified language without all of the coerced statement acknowledgements. And as far as the form that was uploaded yesterday to the website, I have no problem with that, and nor with the exclusion language. I think that's pretty much in line with the statute, and they have I think that form, as long as the rule says shall be exempt in the actual rule, then that's aligned, and it works. It fits.
Director Morrell?
Madam Chair, I would agree with the representative if the only bill in play here was 1065. That specifically deals with removing the notarization requirement. It's 1487 that has the other requirements, requiring acknowledgement by the parents.
Thank you.
Madam Chair, but again, that's two different rules we're talking about here. We're talking about HEP 30113, which is dealing with the exemption language. But then you go on, and it's an entirely different rule under 307.07, which is dealing with the removal from the registry. So those two aren't interplayed at all. They're two separate rules. So the acknowledgement piece, the statutory requirement of 1487 for acknowledgement is in 307, 30707. That is the registry conversation. However, the 1035 conversation, which is 30113, doesn't have any requirement for acknowledgement in the statute at all. So I want to make sure we're talking about two different statutes, two different sections of law. One does have an acknowledgement requirement when you're asking to remove yourself from the registry. The other one does not have a requirement of acknowledgement.
Okay, we can go around like this for a while. Does anyone have a motion
I move to object to the rule
on the basis of?
on the basis of it exceeds statutory authority.
Okay, motion by Lang, second by Erstein, and Representative Hewitt, you have a comment? Okay, any discussion, comments? Senator Prentice.
Thank you, Chair McGuire. So just, I want to clarify, I'm hearing from staff, even though I have heard Representatives Lang's comments about two different statutes. Do they have the authority or not, Mike? Has this part of it been pondered that way, or was this all consolidated into one form for a reason?
I think the department would have to answer that. And I guess Representative Lang's last comments do raise a question in my mind, and I think the department might be able to better clarify that.
Department?
I apologize. And what did you need the department to clarify? The acknowledgements on the forms?
So to
Follow, yes.
Mr. Morell's statement was the acknowledgement is a requirement under RSA 1487 for the removal that parents are acknowledged, get information or acknowledge certain informational facts. However, under 1035, there was no additional requirements made under that bill to require informational facts or acknowledgement of anything. Strictly that a parent has the right to request a religious exemption. And we're adding new requirements that weren't in the bill and aren't in the statute.
And the House Bill 1487 is about withdrawal from the registry. And one can, you have to make these comments, but withdrawal from the registry is not the same as exempting yourself from receiving the vaccinations.
Correct. We did do that in one rule package, so it could be one interim rule and go forward at the same time. We do understand that is two separate rules, two separate issues. Yes. We did that for ease of having it in one package together.
Okay, so
and with respect to the understandings on the religious exemption certificate form that we're putting forward, we are happy to remove those.
Madam Chair,
Yeah.
because I'm trying now. So I guess my question becomes, is that if we were looking at this new rule, 130113 interim rule, and you stopped at where you have the number and change it to the August of 22 period and stop there and removed everything else down to section 2, is that what you're recommending?
So with respect to, yes, I apologize. I was just strictly looking at the form.
Yeah.
So with respect to that and removing those understandings from that first form that's in HEP 30113E, we would then end. I apologize. I'm just trying to.
You would delete the three
We would delete the
paragraphs.
understandings, and I believe you guys
With
may
the
have it.
acknowledgement that they
Yeah,
understand
we would.
all of those three
Yeah,
comments.
we would delete.
And would we
Which
go
one?
back to using the form that you have currently
You have
posted,
to-
the August 22nd form, which is this one? That doesn't require the medical data, which again is outside of statute.
I apologize.
No, I think we're fine with removing that.
We're fine with. Yes, so we are fine with removing. So it would be E1 and 2, and all the middle acknowledgments.
And using the August 22nd form.
No, we would remove it from the September 22 form.
Yes. Senator Bray and then Senator Prentice.
So as I understand it, if we choose to go this way, then the appropriate motion would be conditionally approved. Is that correct? They already have a conditional approval request. If it's clear.
I'm sorry. They already have a conditional approval request, and this could be added to that as long as it's explicitly clear what the language is going to be.
Okay, so that is that, okay?
I'm just
Senator
trying to determine
Prentice?
if I have to withdraw my objection based on what they've said. And I'm trying to make sure it's clear to
Okay,
Attorney Morell's
so
point.
the motion as I understand it would be to conditionally accept the conditional approval response with the following additional comments, namely to delete those 3 paragraphs on risks from the form
Yep, and in the rule text.
and in the rule,
Yes.
and eliminate the list of vaccines. Is that part of your agreement or yours?
We weren't. That was not something that we proposed, but
Well, you'd have to change the form also to indicate that those things are on the form.
Thank you. I just wanted to add, would it be, there are many folks that do religiously exempt from vaccinations that would understand the risk to other children if there were to be an outbreak. So we'd be open to having the list of vaccinations with the checkbox be optional as a first suggestion, because there are folks that don't have a problem with having that information reported to the school nurse, but it is important information to have for public health reasons. So I would just suggest that if possible.
Okay.
For consideration.
Thank you. Is that acceptable, that it's an optional list of vaccines? I think we really need to see.
Yeah,
this.
I think, Madam Chair, we're getting so deep into the weeds, and without seeing a physical form, I think I'm going to stick with my objection and let them come back next month with another conditional approval or some rule or something, response to the
Okay,
objection, so we
you're
can have that.
making an objection to the form based on statute.
they want to see it. Okay.
Senator Prentice.
Thank you, Chair McGuire. I just think we need to see the clean form. I don't want to necessarily object or approve. I don't know what the proper pathway to go is. I think that the department already has this in play, and now it feels a little bit respectfully on the fly, like we're going to eliminate this, we're going to put this in.
I agree.
Thank you. So with
would
respect to the
would the department be able to have a revised form and a revised rule for our continued meeting yes. Thank you. I think that's the best way to go, because it sounds like we've more or less reached agreement, but we'd all like to confirm that.
And I do just want to confirm before we go back, so we're on the same page, that we will remove those understandings from the form and the rule and make the vaccinations that you are exempting from be an optional.
And I trust you will post you will either take the form off your website.
Yes.
Or say, this is a suggested form, parents, you can just send a letter.
And I do want to point out, if anybody is looking at the administrative rules webpage, you will see these forms because we do post what we're bringing forward. Just noting that it's a little different than program web pages to the public.
On the administrative rules website, it's clearly the
Yes.
proposal and not the
Yes.
final rule. On your website, it's what they've got to do to get the kid in school.
So it will be posted twice on our website, one on mine specifically, almost like how OLS posts theirs as well.
Okay.
Madam Chair,
Yes.
just a matter of procedure and cleaning up. So there's currently a motion and a second on the floor to object. And is that, is that the proper course so that they can come back and clarify the objection and clarify the rule and clean it up next month?
Yes,
Um,
they have I believe they can come forward with a revised conditional approval request.
They could. I didn't
Or
know
response to the
if-
objection?
If the goal was to postpone to the continued meeting rather than object.
Yeah, I think that we're postponing the action on that existing motion to the continued meeting until we can see what they come up with.
The continued meeting is October 6th.
Right.
And the motion will remain until it's taken up.
So the
again
motion
there.
we're picking up is to object unless they come back with something better that we like.
Yes.
Is that what I'm understanding?
Yes.
I'm cool with that.
Okay. Agreeable. We will await your response. Thank you. And
Thank you.
is there any other business that needs to be taken care of?
Just for the committee's benefit, I wanted to apologize for all the postponed items. We had a backlog from last month and because of staff illnesses, so we have suggested the continued meeting to get rid of that backlog and hopefully we don't have a huge agenda in October.
Yes, we
It-
do need to catch up.
And on that note, we have hired somebody to replace Diane. She will be starting in 2 weeks. And we're expecting Christina back in the next week to 2 weeks.
All right, we are expecting an efficient meeting on the 6th with only one confusing issue. All right, thank you. All right. By consensus, we're adjourned.
Can recess.
We are recessed until the continued meeting. My
Thank you.
bad.